We're live.
Okay, got it. Good morning. This is Friday, March 1st, 2024. Can't believe it's the meteorology spring, according to the meteorologists down here. So, happy spring. I wanted to let everybody know on S58. I met yesterday with Senator Baruth and Senator Ron Hinsdale regarding the eviction processes. And they have suggested that we wait to do anything on the sections having to do with evictions of legal tenants, but to keep the flash citing in. The Committee on Economic Development, Housing, and General Affairs is supportive of that section, but is concerned about unintended consequences of the other sections. So we're going to remove those in our next draft of S58 next week or the week after town meeting, and just wanted to alert everybody to that so that you're aware of it. We're going to try to work on it, continue to work on it. There is the possibility that there's a House bill that we can attach sections to it if we can get that somewhat more thoroughly done. So that's the update on S58. As far as Proposition 4 goes, I hope we can vote it out today. So I hope that witnesses can be brief, who particularly those who've testified before on the bill or on the constitutional amendment. Eric has a redraft, and so that's what we will work from. And I'll let Senator Hashim take over.
Sounds good. Thank you, Senator Sears. Eric, the floor is yours.
Yes, thank you. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through the most recent amendment of Proposal 4, which is the proposal to amend the Vermont Constitution to establish essentially a Vermont equal protection parallel to the Equal Protection Clause in 14th Amendment and the 5th Amendment to the United States Constitution. You may recall that in the initial version of the proposed constitutional amendment that the committee had been looking at, the idea was to essentially amend an existing constitutional section, the Common Benefits Clause that already exists in the Constitution, and sort of attach the equal protection language to that. I think one of the things that the committee decided was instead to take a different approach, which is consistent with back in 2019 when this proposal to establish a state equal protection clause was initially talked about. The idea was to, instead of sort of working it into an existing constitutional provision, instead set it out as its own section, its own new section of constitutional law of the Vermont Constitution. So that's what this proposed amendment does. And the other substantive difference is, you remember, there's a list of classifications, protected classes, essentially, that are enumerated in the language to create essentially a prohibition on the state denying equal treatment to people on the basis of their membership in one of these protected classes. The first version of the bill that you looked at included a lengthy list of protected classes, did not include religion. Again, the 2019 version of the bill that was introduced did have religion as a protected class now, and I think the committee decided that approach was better. So those are the two substantive changes to the amendment that you're looking at from me. So if you look, for example, at the purpose section of the proposed amendment, that's page 1, line 11, you see highlighted the word religion because that's added. That's this classification list is exactly the same as the previous version that you looked at with that one addition. So that now the way the language will be written will be that the government can't deny equal treatment and respect under the law on account of a person's race, ethnicity, sex, religion, disability, sexual orientation, gender identity, gender expression, or national origin. Those are the list of protected classes in the statement of purpose. And you'll see them if you turn the page. They are repeated in the substantive language of Article 23, which would be the new constitutional provision that would be added. The article number would be 23. You may recall that the reproductive rights constitutional amendment that was passed within the last couple of years was Article 22. So that was a new article as well. This would propose to add one after that, the next one in sequence, Article 23, entitled Equality of Rights. Again, the language here is the same, with the exception that the word religion is added. Version of that. Let me make sure that I'm looking at the right version here. Just making sure everybody is looking at the right version here.
Unfortunately, that document's not on our webpage. Maybe you want to share the screen.
Unfortunately, I don't have a screen with me right now.
I can get it shared right now. Give me 1 sec.
Does the version that everyone's looking at have a second sentence that starts nothing in this article? In Article 23 or not?
Page 1.
Page 2. So,
Page 2 starts with amendment would
Shall be
expand.
interpreted or applied to for introduction.
yes, exactly.
17, line 17.
Yes. So line 17
Yes.
through 20. So the I should have highlighted that sentence. Now, that sentence was in the 2019 version of the constitutional amendment proposal as it was introduced back then. It was not in the most recent version that you were looking at that didn't create a new constitutional section. It just sort of worked its way into the existing common benefits clause language. So it wouldn't have really fit in that, but just I wanted to highlight that for you because the committee hadn't, I don't think, there was some discussion about whether to include a sentence like this, but I don't know if the committee had concluded on that, so that's why I wanted to highlight that. It'd be easy enough to keep it or strike it, whatever you want to do. But the essence of what that sentence does is if you think about the plain language of lines 14 through 17, in other words, the prohibition on denying equal treatment. So for example, this is the easiest hypothetical example to think about what the effect of that second sentence would be. If you look at the plain language and say, okay, well, the state can't deny equal treatment on the basis of race, for example, right? Now you think about an affirmative action program. It's under that, strictly speaking, a affirmative action program, whether it be in education or state employment or government contracts, whatever it may be, that provided some additional benefit for a person on the basis of race, perhaps a consideration of race in the admissions process, to use college as an example. That's the kind of thing that has been struck down by the United States Supreme Court as an equal protection violation, right? So affirmative action programs, remember, under what used to have been the interpretation of the United States Equal Protection Clause, had been upheld. But recently, the most recent decisions on that subject by the current Supreme Court have struck those down and said that any distinction on the basis of race is unconstitutional. It doesn't matter if the intent of the distinction is to, for example, promote diversity in schools or to remedy historic discrimination, that kind of thing. Does that make sense so far? Yeah. So the reason for the inclusion of that sentence, if the committee decides to include it, you'll see, is to make explicit that the equal protection language of the previous sentence is not going to be, can't be used to strike down, for example, affirmative action type programs. So if you look at the language, nothing in this article shall be interpreted or applied to prevent the adoption or implementation of measures intended to provide equality of treatment and opportunity for members of groups that have historically been subject to discrimination. So the idea there is to make clear that the language in the preceding sentence that says you can't deny equal treatment on the basis of whatever the protected category may be, race, religion, sex, etc., isn't going to mean that that the government can't institute programs to help groups that have been historically subject to discrimination, i.e., for example, an affirmative action type program. So that's the idea. I think, as I say, it was in the proposed language as introduced in 2019. The committee had heard testimony about it, but I don't think there had been a decision either way, and I just left it in there so you could see it and then decide whether you want to keep it or not.
So I'm curious about that. So with the finding that affirmative action, well, can we go back a sec to what you had mentioned about affirmative action in the Supreme Court, and you said that it was found unconstitutional?
Correct.
So would this cause any conflict with that opinion?
Well, in the sense that if someone could still, the U.S., or the federal United States Constitution would still apply. So yes, if someone were to, again, use a hypothetical example, say there was an affirmative action program at a Vermont State College and someone challenged it and said, but they challenged it under the United States Constitution,
Right.
This isn't gonna help.
Right.
It would still be unconstitutional. But if for some reason there was a program, some other type of program, some state benefit, for example, I think the committee may recall, there's numerous places in law over recent years where you've added language, for example, will say, members of a certain board shall be drawn from diverse communities in order to reflect broad experience, that sort of language. If someone, in other words, not something specifically related to affirmative action in education. If someone were to challenge that under the Vermont Constitution, this would be protective.
Mm-hmm.
But it's true that it wouldn't change the result under. If someone decided to, well, I'm going to go to federal court, I'm going to challenge that under the United States Constitution, this isn't going to help.
Right. Okay. Thanks.
Yeah.
So, what are we trying to accomplish here?
You mean with overall, or?
What do we not have in our present Vermont Constitution that this is going to override and protect? Well, what is the purpose of this is my question here.
I think, and I'll defer to some of the sponsors as well to talk about this, but from the perspective of just drafting it, putting it together, it provides a more specific express protection for equal protection than you have in what you have. What now, if someone were to bring a claim, for example, saying that I'm in this particular group of people, this government law is treating me differently because of the fact that I'm in a different group. It would have to be brought under what's known as the Common Benefits Clause of the Vermont Constitution. And that wasn't intended to address situations like this. It has been developed by the Vermont Supreme Court over the years to apply to a similar kind of equal protection claim. But I think the intent here is to be more express and specific and provide clear guidance as to what protected classes are going to be subject to the equal protection language here. It's not clear. There's nothing in the Common Benefits Clause, for example, that talks about religion or ethnicity or sex, disability, etc. Not clear how it would apply. This tries to make it clear, I think.
By mentioning the specific group, chapter 1, article 1, doesn't that provide that same protection?
I don't have that language in front of me, but that's a general natural rights provision, but again, it doesn't have it's not a precise equal protection, but I think it's protecting similar types of rights.
But the scope of it says that, yes, you're all warranted,
all
protected, all persons,
yeah. But I don't know that, I haven't heard, from my understanding of the way an equal protection type claim is brought in Vermont. If it's brought under the Vermont Constitution, that's brought under a different article, not that. And the Supreme Court has said it's a Common Benefits Clause type of analysis. So, not that it's not, I think, attempting to protect people's rights, but not exactly the same.
Senator Sears?
Yeah, I just wanted to, I guess it's part question, part comment. I think that where I'm looking at is if the U.S. Supreme Court struck down gay marriage, for example, and said that, which is something that has been discussed by at least 2 members of the United States Supreme Court. This would still leave us and they left it to the states as they did on Roe. This would mean that Vermont would still recognize. Am I correct? Or would
Yes,
it not?
yep, that's exactly right. So that if the US Supreme Court said that the federal constitution no longer protected same-sex marriage, you would still have it protected by the Vermont Constitution. Now it's also still protected, or at least in a certain sense, by the Baker decision under the Common Benefits Clause as well. But this would explicitly protect it in Vermont, regardless of what the US Supreme Court said about the same right under the federal.
Yeah, but the Baker, to be clear, the Baker decision did not spell out marriage.
Right.
It was same benefits because it was the Common Benefits Clause, and that gay couples deserve the same common benefits that any other couple would have. They never, and that's how we ended up with civil unions in the beginning, and then later on it was changed to marriage, but by the legislature. But I think that's the important distinction here, and that's why I would support this language.
You can keep going, Eric, if you have more to it.
Oh, no,
That's all I had to say. Thank you.
Yeah.
So Eric,
Yeah.
I apologize for coming in late, but just to make sure that I know what I'm looking at, we're on draft 1.1, and this is a new draft from what we had last time. Is that right?
Yeah, it is.
So 1.1, proposal 4,
Yeah,
is that right?
that's true, but for some reason, this is not the document that I saved last night. I'm not sure why. There's an error in it, but mine said, for example, it says Committee on Government Operations, and I did a new amendment last night that it said Judiciary.
Ben, do we have that?
The one that you have is the one that I was sent last night.
Huh, strange. Must be Word somehow didn't save my changes. So anyway, other than that, yes, it's correct.
Well, and I guess my question was directed at, it seems different from the last time we looked at it.
Yes,
Right, so now it's a new section unto itself,
correct.
and religion has been added.
Right.
Okay, and then the second sentence,
Yes, and that's
Has also
the other, and that honestly was part of, it was in the version of the Equal Protection Amendment that was introduced in 2019, that sentence.
right,
And the committee had discussed whether or not to include it in your version, because you talked about two changes, putting it in a separate article and adding religion. And then there'd also been some discussion of whether or not to include some language that clarified the affirmative action type of situation, which is what that sentence is intended to do. However, in the same way that for some reason the changes I made last night didn't get saved with respect to Judiciary Committee first and Government Operations, that sentence, I hadn't included that in the draft. I struck it, and I thought I'd bring it up and we'd talk about it, but it really doesn't matter. But just in the sense of, you include a sentence, sometimes it's different to think, well, it's as if it's there, you know what I mean? But I know the committee hadn't decided that yet. But I thought it might be something you want to chat about because you talked about it before, but I was going to bring it up rather than have it in the draft. Yet somehow it ended up in there, I don't know.
yeah, because we haven't had a lot of discussion of that
Right,
second sentence.
right.
And I understand that the chair was thinking we might vote today, and it seems like if that second sentence is in there, Mr. Chair,
Yes.
is it your intention to vote today?
Well, if we can't, we can't. If you'd rather wait till next week, we can, or the week after town meeting, we can do that. I was just trying to move the agenda forward. We've got quite a
I'm
few
just thinking
bills.
that the last
I'm
time
always
we-
on that edge of, it's more important we get it right than we rush it. So let's put
Yeah.
it that way. So if the committee feels they'd like to spend some time looking at it again after we hear some more testimony. I think it's fine with me. I appreciate the important thing is we get it right. So
Yeah, and my own personal feeling is that, given our discussion last time, I'm confident voting on the creation of the new section, the addition of religion, and that first sentence. But if we're now including that second sentence, then I feel as though I would myself need more discussion of that.
okay.
And you hadn't meant to have it in?
No,
there?
that sentence, and I apologize, was included inadvertently. I don't know, I
Okay.
have no idea how it got in there. I'm positive that I saved the document last night that said, had the correct committee and did not
Okay.
have that sentence. So it was
Okay.
obviously a technical problem.
If I'm at a loss because I don't have the sentence in front of me, but I'm fine with waiting and getting a redraft after we've heard from more witnesses this morning.
Yeah, we should probably wait.
Yeah.
Yeah.
I think that makes sense.
Okay, that's fine. We can, Ben will jiggle the schedule around and I've got, we have 4 days, so. Are constitutional amendments under the same pressure, by the way?
So you don't have to meet crossover.
They don't have to?
No, not for a constitutional amendment.
Okay, so if by some chance we weren't able to get it out by a week from, or 2 weeks from this Friday, we'd still be okay.
Yeah.
Okay, then that makes more sense to get it right than to rush it. But if the sentence wasn't supposed to be there, Eric, let's ignore it for now.
Okay.
Senator Bowles?
I mean, if we're still in discussion about whether or not we want the sentence and we have witnesses in the room, I'd love to hear them weigh in on their thoughts on that sentence.
Sure.
Okay, can we share the screen again so we all, I don't have the sentence in front of me. Unfortunately, the documents I've got. Could you read the sentence exactly, Eric?
Sure. It's, and now it's on the screen, lines 17 through 20.
Okay,
Nothing in this article shall be interpreted or applied to prevent the adoption or implementation of measures intended to provide equality of treatment and opportunities for members of groups that have historically been subject to discrimination.
okay. But you don't know how it got in there.
Well, it was in the version of the constitutional amendment that was introduced in 2019. So when the committee decided to go with a separate article rather than just amending the existing common benefits clause, I pulled some language out of that 2019 introduced amendment. And then prior to saving the document, I struck that sentence and changed the committee from government operations to judiciary and made a few other changes, but evidently they didn't save for some reason.
Okay.
So that's how that sentence ended up still being on.
Yeah, whether that should be there or not be there is an issue that needs to be discussed.
So, Senator Sears, unless, I don't think the committee has any other questions for Eric.
Okay.
I think, are you all set?
Yeah, I'm all set.
Yeah, I'm all set.
And I'm just looking at the clock. I know we have 45 minutes and we have 3 witnesses.
Yep.
Do you want to keep talking with Eric or do you want us to move on?
No. Now I've seen the sentence and I understand what we're doing and we're not going to vote today. So let's hear from the witnesses and then try to schedule some time for markup of the constitutional amendment.
Sounds good.
All right. Well, good morning. I'm Paul Schilling, Advocacy Director for the ACLU of Vermont, and also in the room with me is my colleague Harrison Stark, one of our staff attorneys, and really appreciate the opportunity to testify to you on this amendment. We did send some proposed changes to the amendment to the committee for your consideration, and I will do my best to respond to the changes in draft 1.1, having just kind of seen the walkthrough and try and address some of those. So how I plan to work through this is, we have proposed changes that I think are on your website, but I can kind of speak from a high level first, about how we're approaching this, and to say that we strongly support the intention and the goals of this amendment, to provide more equal protection under our state constitution, have an explicit equal protection clause that does not exist at this point in time. And from what I've heard from the testimony in this room from sponsors and from witnesses, it seems like one of those goals is to make sure that we have more robust equal protections under our state constitution than exist under the federal constitution. So our amendment, our proposals are brought to you in that vein. We're not trying to slow anything down or make things harder, but and as we go through these, some of these are for discussion, and I'll try and highlight the ones we think might be the most important to try and help make sure that this accomplishes that purpose. So the first, and when you go through our changes, I think the first thing you saw that we did already was done in draft 1.1, where we separated out this language into its own article. We think that's a beneficial change because it makes it cleaner, it does not in any way, it can't be implied that it's interacting with Article 7 if it's its own standalone amendment, and makes it easier for people to understand the goals and just cleaner to read, easier to apply. So I think we appreciate that change in draft 1.1 and would support it. When you look at our draft, we did make some changes, proposed changes to the list of protected groups and categories. And through those, one was we proposed the addition of economic hardship. Because when you look at the bill, it speaks to trying to remedy things like economic hardship in the purpose section. And we thought that it would make sense to make sure that that was explicit within the actual language of the amendment. This is something for the committee to consider. And also, especially when we look at the ways that people who are lower income and experience economic insecurity face many barriers to challenges of daily living. We want to make sure that the government is not in itself creating more barriers or putting barriers between people and their ability to enjoy their basic constitutional rights. So that's something that we thought would make sense based on what was in the purpose section, but that's something that's up for the committee discussion. If you look at our proposal, you know, one thing we did not add was we did not add in religion to that list of proposed categories, mostly because we believe that there's already, well, we know that there's already explicit protections for religion under Article 3. And looking at a similar construct to what you see in the federal constitution, religion is not part of the Equal Protection Clause of the federal constitution. It's its own, it is encapsulated in the First Amendment. And if we're trying to mirror that type of construct, we thought that that would make sense. So we did not include it, but that is a choice for the committee to look at. And then we did slightly modify the language around sex and putting things like, let me look at the actual language. So we tried to encapsulate sexual orientation, gender identity, or gender expression underneath sex, because in existing federal jurisprudence, there has been protections found for that broader expression of sex under federal law. And that is also a more, in making that an included but not limited to list, provides the opportunity for a more expansive reading of sex under the Constitution and to allow for our jurisprudence to evolve as we evolve as a society and make sure those protections are there.
So just to clarify, Falco, are you saying that you wouldn't name orientation, identity, expression explicitly? You would assume them to be under sex?
No, I'm sorry. I'm sorry if that was the impression. So what we would propose, we would say sex, comma, including but not limited to or gender orientation, gender identity, sexual orientation, gender identity, or gender expression.
I would be very uncomfortable with saying including but not limited to, because we're articulating a list. But what adding that would say is that other things might fall under this, but we're not going to name them.
I think the idea is to not trying to limit, but allow for an evolving understanding of what is protected under sex, sexual expression, expression of gender identity, and other things like that.
But I think if you say including but not limited to, you're explicitly saying that there may well be other things, but we're not doing that for any of the other items. You know what I mean? So we're creating a list where we're literally naming the protected classes. But if we added including but not limited to, we're explicitly saying that there can be other things that fall under this. So it seems that that's at cross purposes.
I don't think it's at cross purposes, but I do think it would be treating those classes within the amendment somewhat differently. I don't know, Harrison, you want to chime in at all?
Sure. I mean, I think the our intent behind that suggestion was that the evolving of what constitutes sex discrimination has evolved over time, and the goal of this edit, I think, was twofold. One, to just make clear that when this amendment says sex, it's embracing a broad understanding of that term and not just sort of a narrow biological construct, and that the things that have fallen under sex discrimination, how we think about it now, have changed and often changed kind of rapidly. And so by saying this definitely includes sexual orientation, gender expression, or gender identity, it leaves room for other components of gender to be protected under this amendment in the future. And I think by putting this under the umbrella of sex discrimination, there's not really a risk of a limitless list of sort of additional categories coming under protection, but making clear that this all falls under one umbrella of a broad understanding of sex discrimination.
I think I personally agree with Senator Baruth. It's dangerous, I think, to put in, but not limited to, because just looking at the Vermont Supreme Court's interpretation of our bail laws may not match what the legislature intended at the time they passed the constitutional amendment in 1992. And there's a record there. And I think if you leave something like that, but not limited to, it leaves the court wondering, and who knows how a Vermont Supreme Court might find. I'm not suggesting that they would be irresponsible, but on the other hand, you're leaving, I think, very important sections to their interpretation of what the legislature meant by not limited to.
I completely understand that, and I think as we look at the changes, that's something that's up for the committee to consider.
When we get the markup, I flagged that because our recent experience yesterday of going over a Supreme Court decision on bail and what people thought they were doing in 1991 or 92 and passing the amendment out of the legislature and how the Supreme Court interpreted it.
Well, I'm happy to move on from looking at the list of protected categories. I'd speak to the two other changes we had in there, which we actually think are probably the most important changes within, this could be drafted different ways based on how Legislative Council wants to do it. But within what we would envision as Section 3, which is now the effective date, but making more explicit in the execution. Actually, no, this is within the language itself. Sorry, I jumped ahead. We proposed adding into the language itself the words intent or effect. So that would read, the government shall not deny equal treatment and respect under the law in intent or effect. And this is an important change to make it clear that the courts that a violation of this article would occur when the government acted with either the intent of denying equal protection or the effect of denying equal protection. And this is one of the chief limitations of federal equal protection jurisprudence currently, is that it prohibits discrimination or animus, which is a pretty high bar based on intent. And so adding effects-based language would allow for people to seek remedy when they can show laws deprive them of equal access or treatment, regardless of having to prove ill intent from the government. So that is an addition that we think would make sense to put in there and would actually help move this to where folks are, where folks are hoping it will go, to add more protections than currently exist under federal equal protection law, where you have to find that, the discriminatory intent. And then finally, I jumped ahead, but within the either purpose or execution language, want to make sure that there's language in there to make it clear this article would be self-executing, meaning that individuals have the right to bring suit for violations of the article. The Supreme Court of Vermont has found that some articles of the Vermont Constitution are self-executing and others are not. And it seems like it's been the intent of this committee to make sure that this is an article where people would be able to bring suit for violations that happen. And that would just make that explicit for any future court when looking at the legislative intent behind these proposed changes. So I think that is all I had, and I'm happy to take any questions.
I have two questions. What, can you repeat what you just said? I didn't fully understand. Your last sentence or two.
That the idea that to make it explicit in the purpose section that this article be self-executing, which means that an individual would have the ability to bring a suit against the government for these violations on their own. So the Supreme Court has found that some articles of the Vermont Constitution are self-executing, meaning they allow people to bring suit directly for violations, whereas other articles have not found to be found self-executing. Harrison, do you want to add anything more there?
Yeah, just that essentially self-executing means it has legal force by itself just by being in the Constitution. So some amendments have legal force of their own, others essentially need power from the legislature or sort of other authorization. This would just make clear that this has legal force by itself and it can be enforced essentially as soon as it's added to the Constitution.
I guess my question would be, why wouldn't it be able to be enforced without the self-executing clause?
I think that, as drafted, there would be a reasonably high chance that the Vermont Supreme Court, looking at the language, would conclude that it is meant to be self-executing. This just removes any doubt at all. So there's no chance that a court looking at it could say, well, actually for this amendment to operate, it needs an additional authorization from the legislature or anything like that.
And did you mention that that's already in other, do we have self-executing provisions in other articles?
Yes. The Vermont Supreme Court has concluded that some articles, like, for example, Article 11, privacy protections, is self-executing. Others are not.
Is it, Mike, one sec. Is it explicitly written in Article 11 that it's self-executing?
It's not, and courts have sometimes struggled to look at the language and try to determine what the legislature intended, whether the legislature intended it to be self-executing or intended for there to be an additional step. This would just remove any doubt and make clear that the legislature wants this to be enforced as soon as it's added to the Constitution.
You're suggesting have that in the purpose or the language that would go into the amendment?
This would be in section 3 under our proposal. So it would have the effective date, and it would just make clear that on that effective date, it has the full force of law as a self-executing.
Yeah, the only reason I'm asking is because, if it's not explicitly written in other articles, I wouldn't want to create a precedent where it has to be explicit in the article. And then, in the future, when the Supreme Court is looking at other articles and they would say, well, this equal rights amendment, it has an explicit self-executing clause in it, but these other articles don't, therefore, you get what I'm saying?
Yeah, no, I think we fully agree, and that's why we didn't propose to put it into the actual language of the amendment, but just to make the intent of the legislature clear, because from what I've heard in the conversations, that seems to be the goal of the people proposing this amendment and many of the proponents.
Okay, I just wanted to clarify that. Thank you.
Yeah.
Any other questions? Great, thank you.
Thank you so much.
And then next we have Reverend Hughes.
Yeah, I'm kind of stuck over here. I'm going to need a couple minutes. And I think you said you had 3 witnesses. Can you just come back to me?
Sure, we can come back in 15 minutes and we can, Carrie, are you good to go, Ms. Brown? Okay, great.
Good morning. I'm Carrie Brown. I'm the Executive Director of the Vermont Commission on Women, and thank you very much for the opportunity to testify on this amendment. Just to give you a little overview of the Commission on Women, we're a state agency. We're charged with providing advice and counsel to the legislative and executive branches on matters concerning the status of women in Vermont. And so, as you will not be surprised to hear, the addition of a constitutional amendment to specify that rights should not be abridged on the basis of sex has long been on our to-do list. In the 1980s, the constitutional amendment that addressed sex, made its way through the legislature, did not pass at the polls. And in the time that has elapsed since then, the Commission on Women in general has recognized, and I think that this is reflective of the culture in Vermont and in the rest of the world, has recognized that a view of expanding equal rights to include sex and not other protected categories is limited and exclusive and just completely inappropriate. And so we were very engaged with the 2019 proposal to create an amendment to the Constitution that expanded beyond sex discrimination to all these other categories. And we are very supportive of the current proposal to the amendment. And I would say that the latest version that you have that sets it as a separate article rather than incorporating into the common benefits article is we are much more supportive of that than the first approach. So that we're really happy about the direction that's going. So I won't repeat too much of things that you've already heard from other witnesses, just to say that part of why this is important to have as its own addition to the Constitution and not rely on what's currently in the Constitution is to ensure that strict scrutiny would apply or a higher level of judicial review would apply to these specified categories. And I'm not going, because I'm not an attorney, but I have an attorney that I can consult with. I don't want to address too much the question of which categories are, whether we specify, whether we limit it to a specific list of categories or if we expand it to, may otherwise include or including but not limited to, that kind of thing. It's true that we have really evolving ideas about sex discrimination, for example. But we need to be careful about whether we're, which ones we want to explicitly apply that strict scrutiny to. And so including this in the Constitution is a way for the state to make a clear statement on what its intent is also a way to protect against future legislative action. Vermont has been recently expanding its equal pay laws that initially were applied only to cases of sex discrimination in pay, and expanded that last year, and the House recently passed another bill just last month to expand it even further. And so, clarifying that these are protected constitutionally is, we feel, extremely important. And then I think those are the key points that I wanted to address. I'm happy to take any questions. I'll try not to repeat too much of what you've heard from other folks and any questions. Yeah.
Thank you. I have one question that actually might be for Eric, but I just wanted to touch on something you had mentioned about strict scrutiny. Mm-hmm. I think, Eric, and correct me if I'm wrong, but my understanding was that issues related to sex and gender fall under intermediate scrutiny.
Correct.
So they would remain under intermediate scrutiny, even though they're under this.
Well, that's the way it is under the federal Constitution. Right. It's intermediate scrutiny. It's going to be up to the court ultimately to say if you were to add a new list of protected categories, for example, the court might continue with what the federal precedent was on that, but on the other hand, they could decide that it would be subject to a more heightened level, strict scrutiny. It's possible. The court could decide that that was what the legislature intended by including that specified list of protected classes. So it certainly wouldn't be any below intermediate, but potentially it could be more protected.
Mm-hmm. And that would be the hope, that specifying it would do that. And of course, we don't know exactly what the court will do in their interpretation, but that would be the intent.
Thank you.
I imagine, thank you for being here, that you have a pretty robust set of data showing that right now women are not always treated entirely equally. And I'm wondering if over time you have started to compile data about the intersections of women and disability, or women and race, or is that?
That is actually something that we have been starting to do in recent years, and to understand that the concept of intersectionality, which tells us that there are different ways that people can experience discrimination, but then the combination of different ways is kind of also its own category. And so there are lots of ways where the law is trying to address this. The expansion of the equal pay law really is trying to kind of get at that, as well as workplace discrimination laws and sexual harassment laws and other kinds of workplace harassment laws, to recognize that if you're, previously, many courts would say, if you're a Black woman who's experienced discrimination at work, that you have to choose. Am I going to, complain about the racial discrimination, or am I going to complain about the sex discrimination? And recognizing that these things often work together. And so we don't have nearly as much data as I would like to have. We have been really focusing in recent years on looking at the pay disparities. So Equal Pay Day is a symbolic day coming up this month that signifies how far women have to work into the next year to make what men made the year before. But the average of all women is very different from how far Native women have to work, how far Black women have to work. There's huge, huge differences. And so we have some data like that. We could really use a lot more, for sure.
And so given that we're starting to sort of look at those intersections more, is this proposal a helpful way to sort of lift up and protect in a more inclusive way?
It is, it really is, yeah. And then the sentence, the second sentence that you all were discussing earlier that may or may not be included, we feel that would actually be very helpful and, help along these lines too, so that we're recognizing that there may be cases where there's disparate treatment under the law in order to rectify past harms, and an understanding of intersectionality definitely plays into that.
Thank you.
Thank you.
Thank you very much.
Senator Sears, did you have any questions? You're muted.
I appreciate the testimony from the Commission on Women, and I'm glad to hear that they're supportive of the changes that we've made to make it a separate article. I think that was an important step forward to make clear. And I'm sure there are a number of places where the United States Supreme Court has made us all very nervous about equal protections. And hopefully that's my motivation on this article.
Thank you.
Thank you. So looking at the agenda, and I see we're supposed to be at 10:15 is when the vote is happening for the Sergeant at Arms. I don't know if that means we're supposed to be on the Senate floor at 10:15 or.
I think 10:20 is the time you're supposed to be on the Senate floor.
Okay, sounds good. So we've got Reverend Hughes. You good to go?
Yeah, I think I'm good to go. I'm wrestling with a printer over here, but I'll just wing it. So first of all, I'll just, for those who understand rabbit, I'll say that, and happy March to all of you. I'm Reverend Mark Hughes. I'm the director of my Racial Justice Alliance. Coming back with this testimony, I just wanted to, first of all, just acknowledge that I only saw the first the strike all this morning. Obviously, everybody, I think, just got the strike all this morning. We were definitely I was looking for it last night, and actually prepared a strike all of my own that I've yet to send over to the committee because I was still working on it this morning. I don't have the luxury of a staff or assistance or anything like that, or even legal support in this matter to the extent that we'd like, because this subject is not very popular amongst attorneys, actually. So again, good morning. People, as there's we did have some additional testimony that we wanted to offer, and just wanted to start in with, in addition to unemployment roughly being 2 times the unemployment rate for white folks, for Black folks since it's been on record. That 20.3% Black folks here in Vermont live in poverty, where 10% white folks do. And the median income of Black folks in Vermont is 43.6 thousand, while whites are 68.4 thousand. This is all ACS data. And then there's 0.2% farmland in the state is owned by Black folks, 0.2%, while 99.7% is owned by whites. And 33% of Black third graders, particularly in language arts, where 50% of whites are. None of those numbers are very good. And of course, 1.5% of the population is Black, where 11% of our prisons are. Troubling is the fact that these disparities, they exist not simply as a residual of the institution of slavery, but also as a result of our policies post-Reconstruction in Maine today. Troubling is that these harms that the 14th Amendment Equal Protection Clause has proven ineffective to address them, to redress them. And more troubling is, as I discussed in previous testimony, the jurisprudence, which I've heard a lot of conversation about today, of the amendment. The 14th Amendment, in fact, inflicts some of these harms, contributing to the perpetuation of systemic racism and other forms of systemic oppression, back to that intersection that we were talking about a moment ago. A series of SCOTUS equal protection scrutiny rulings have made it all but impossible to implement corrective government program enactments that address these disparities. So what I'd like to get at today, I'm going to skip through some of this written testimony, which I've yet to live the person. Dog ate my homework again last night. But I will go into just a little bit about a question that I asked Professor Teachout when he last testified, and I asked him, given the fact that we do not have a constitutional equal protection clause today, and if we were to implement one, would that leave us with the ability to adopt our own analysis, if you will? We refer to as basic analysis, or the evaluation of our equal protection clause to establish statewide jurisdiction. His answer was yes. So I was hoping to maybe get outside of the box, if you will, that the committee is operating within with the jurisprudence, because the jurisprudence is harmful. It's not very helpful. And to the extent that we are able, as we create a new constitutional amendment, I believe that it's imperative that we speak in terms of the creation of jurisprudence as well. And what that goes into is some of that further to be the intent. I'll say that the basic analysis doctrine impedes the ability to address systemic racism. This rational basis review is a standard of judicial review. It applies to the courts when addressing laws challenged under the equal protection clause. It seems that courts are deferring to legislative discretion to uphold laws as long as they are rationally related. And obviously, strict scrutiny applies to those. But these standards, obviously, they tend to make it more difficult to challenge the laws of the policy that result in disparate outcomes, systemic racism, or other case systemic racism. So I guess what I'm saying here is that the equal protection clause provides it does provide a potential avenue for addressing disparate outcomes, the 14th Amendment to Equal Protection Clause. But the basic analysis doctrine, it's posing a significant challenge to effectively challenging discriminatory laws or policies. I think, as we continue down this path, the analysis doctrine it's an obstacle for the creation of corrective policies designed to address disparate outcomes. I think one issue specifically is the challenges in demonstrating discriminatory intent. I think part of that conversation was here in the room a moment ago. Policies aimed at addressing systemic racism may be some of the legal challenges, alleging that they discriminate against certain groups, particularly if they involve affirmative action or targeted interventions. Proving the constitutionality of these policies under the basic analysis doctrine can be difficult, especially if the opponent argues that they lack legitimate government interest. And I think legitimate government interest, I think, is really important to talk about the version of the constitutional amendment, the language that we'll be submitting for the record for your consideration. And its purpose does speak to the goals, the intentions. So I guess though basic analysis is intended to provide a framework for assessing the constitutionality of laws and policies, its application, it definitely can pose some challenges to the creation of corrective policy. And to, no matter how we pursue this, it's important that we take that into account. I want to just refer you to what should have been placed on record from my last testimony, a summary of some of the resources that I submitted, the Harvard Civil Rights, Civil Liberties Law Review, a section starting at page 48, the conversation that goes into the current failure of state constitutions. And it starts out with the unimaginative parallelism. That document should be on record as a result of my last testimony. I also want to bring to the attention the Harvard Law Review for January 77. It's Rev 489, and it talks about state constitution and the protection of individual rights, and it gets into some of the issues that I just raised. One would think that, with the court's stare decisis, the principle of stare decisis, which means to stand by things decided, would be a protection that the public opinion and political backlash and judicial restraint, institutional integrity, the evolution of legal doctrine, and checks and balances would help us in the implementation of the current 14th Amendment. But SCOTUS is already impinged upon stare decisis when it overturned Roe versus Wade. Public opinion of the SCOTUS is at an all-time low as a result of recent ethical challenges exhibited by the justices. The SCOTUS credibility has been undermined over the past several years because the court has been conservative for nearly all of its existence, with the exception of 10 years, roughly about. And the Equal Protection Clause has rarely been interpreted in a manner that has given it the power that it requires. Further, as a result of this, the existing jurisprudence of the Equal Protection Clause serves Black people poorly in the United States. The recent overturning of the affirmative action at Harvard and UNC Chapel Hill illustrates the reversal of established civil rights protections protected by the Equal Protection Clause. Plessy versus Ferguson, United States, and Cruikshank and other precedents reinforce the SCOTUS proven propensity to reverse established civil rights protections protected under the Protection Clause. Now, with the supermajority Supreme Court, and given the current and national racial climate inflamed by political backlash, what is what's going on is a certain risk of reversal of established civil rights protections protected by the current equal protection clause. So there is indeed a risk of that the established civil rights protections protected by the equal protection clause could face reversal or erosion in cases involving affirmative action, voting rights, and other areas where systemic racism persists. I think that as far as the, moving forward, there's, instead of getting into the detail on some of this testimony, I will just jump to back to the idea of constitutional amendment as it is written. Again, I did not have the privilege of seeing the proposed language until I joined this call, but I'll just leave it by saying that, and I'll just read this, is that the language that we're proposing is that, I quote, the people, this is the actual Article 23 of, obviously we concur with the article being a separate article, that the people are guaranteed equal protection under the law, that the state shall not deny equal treatment and respect under the law on account of a person's race, ethnicity, sex, religion, disability, sexual orientation, gender identity, or national origin. Nothing in this article shall be interpreted or applied to prevent the adoption or implementation of measures intended to provide equity and opportunity for members of groups that have historically been subject to discrimination. And then finally, we add, the General Assembly shall have power to enforce by appropriate legislation the provisions of this article, and that is in concurrence with Professor Teachout's recommendation, providing the general constitutionally providing the General Assembly power to enforce the laws. I'll pause there for a minute for questions and then come back for conclusions. I see Senator Bahovsky has her hand up.
Yeah, thanks, Mark. I actually have a question for Eric, I think, and that is about that last piece. Isn't it by Constitution our job to enact legislation that upholds the Constitution? Do we need to state that?
You don't need to, but occasionally it is. I don't think it's necessary in order for the General Assembly to enact statutes that you can defend as pursuant to the equal protection power. It's really a matter of whether you want it to be explicit or not.
Are you aware, and you may not be, if there are other articles in the Constitution that explicitly say that?
The one I know of has to do with, it's in the sections related to the judicial branch. For example, that there's a creation of a judicial nominating board, that there's processes around what happens when there's a vacancy and how the vacancy gets filled. There's a sentence that similarly says the General Assembly may, well, I'll pull it up for you, but it's a parallel sentence.
Okay.
I'm not sure if there's another one, but that's the one I know.
Okay, thanks.
Yeah.
Just sort of similar to Senator Hashim's point earlier, if we start putting things in places that give us explicit power that is assumed in other places, I don't want the Supreme Court to start assuming that it's not applicable in the places where that doesn't exist.
Right.
I would add that the 14th Amendment of the United States Constitution also has similar language. Other questions for me as I move towards closing?
Not seeing anything else in the room.
I want to really go to
Reverend Hughes, just so you know, we do have, I want to say, 3 or 4 minutes before we have to head off to the floor, just so you know.
Okay. Using intent to eradicate systemic racism and or other systems of oppression as a state compelling interest in the development of this constitutional amendment is absolutely critical. Using the intent to eradicate systemic racism and or other systems of oppression. A senator asked at the top of this meeting, what are we here for? Why are we doing this? The contemporaneous notes and the purpose is what legally will be looked back upon in decades to come. It is incredibly important that the language and the construction of this constitutional amendment in the category of purpose, which we will provide after this, there's meticulously, we've gone through and created language that goes right to the heart of why it is we're doing this. The last time I testified, I told you that, and we just covered this a moment ago, is that there are current efforts underway that are faced with obstacles to address the legacy of slavery and systemic racism and systemic oppression. There are certain protections that are currently on the books that are at risk. We've talked about that as well, and we also talked about the fact that currently the policies, the 14th Amendment and the Equal Protection Clause do not sufficiently protect all classifications. So there are expansions that we need as well. Moreover, there is a certain level of challenges that we are seeking to address that have more to do with the policies that are currently being created that are undefensible because we don't know how to challenge them, but yet and still they're creating disparities in our communities. So there are a number of areas that this is important. So I would just say incorporating this type of language is incredibly important, specifying the objectives, the principles of the policies, incorporating the intent to eradicate systemic racism and or other systems of oppression is incredibly important. I'll leave there. I will submit the proposed language that I've just gone over, as well as the intent, even if we were restricted to the current jurisprudence with the basic analysis that we're currently using, we would still need to provide the intent and it would need to be, it would need to address a state's, our state's, I guess, the challenge that we're trying to address. I'll just, I think in the last seconds here, I would just say that one of the segments here is that systemic racism and other forms of systemic oppression create wealth disparities and indirectly affect health and wellness, and they threaten the economic development, and they actually place our democracy at risk. So a compelling state interest exists to eradicate systemic racism and other systems of oppression in this state. I'll submit what I have. Thank you for your time.
Thank you, Reverend. Senator Sears, I think we're good to go, unless you have anything. Yeah, you're muted, Senator Sears.
That we have completed all testimony. We will begin markup sometime, hopefully the week after town meeting of Proposal 4. And Ben and I will, and Senator Sheen will work on an agenda to see if we can fit it in. If not, we'll do it soon after we complete the crossover deadline.